Joining me now to discuss the dangers of a clearly left-wing judiciary and the implications for the safety and the security of the nation are Josh Blackman, Associate Professor at South Texas College of Law in Houston, an adjunct scholar at the Cato Institute, and attorney Barbara Smith. She served as law clerk to Justice Samuel Alito, and we thank you both for being with us. It is an amazing spectacle to behold. Back on February 3rd, when the Washington State District Court judge put the president's original order on hold, staying that order till now, where two judges are absolutely outside the language of the order, no reference to the Constitution or the code which justifies the president's, gives him the authority to do exactly as he has ordered. Let me start with you, Barbara. What is going on here?
Yeah, Lou, I think you really hit the nail on the head. The thing that bothers me about the opinion out of Hawaii is the same thing that bothered me about the Ninth Circuit panel opinion, which is just this is not how law is done in the federal courts. Judges don't look through Twitter feeds and in press releases to try and find evidence. They're supposed to read the text of the statute, or in this case, the executive order that they're reviewing, the evidence presented by the government, and make a decision based on the law. You know, I think this actually reminds me of something that Judge Gorsuch said early in his confirmation and nomination process, which was if you're a federal judge and you find yourself always agreeing with the policy outcome of the particular legal decision you're making, then you're probably doing it wrong. And I hope that that's not what's happening here, but I sort of fear that it is.
Yeah, it seems clear that that is precisely what is happening here. Josh, your thoughts?
It seems that the federal courts look at President Trump's executive order the same way Rachel Maddow looks at his tax returns, looking at every conceivable way to find something wrong with it, to look at the record, to look at his tweets, look at his statements from 5 years ago. I'll tell you, one of the judges in Virginia quoted Donald Trump from 2011 on the O'Reilly factor, talking at the Ground Zero Mosque, as evidence that this is an animus, a bias towards Muslims. This is beyond the pale and far beyond anything courts should consider when deciding the constitutionality of the president's actions. So
let me ask you both. What we are encountering as a layman, as everyone, nearly everyone watching you all tonight, is common sense tells us that these two judges are acting like damn fools. They are pushing their politics. It is outside the law. It is outside the Constitution of the United States. Where is our judiciary? Is there not an objective power within the judiciary that says to these judges, cut it out? This is ridiculous, and you're making a mockery of our judicial system. Barbara?
Well, so I think the good news, Lou, is this is exactly why we have appellate courts and appellate courts on top of those appellate courts, is precisely so that if you get, you know, a decision from a district court judge that maybe isn't quite in line with what the law actually says, you have the ability to appeal it and to take that ruling up to the next level. So, you know, I think the rule of law is still safe in America. I wouldn't quite go so far as you have, but I do agree with you that these decisions are not right on the law as I read it.
Yeah, I think, and I understand your constraint, and perhaps you understand my lack of it, because I'm outraged to think that our court system would behave in this way, and with one judge in Hawaii making a fool of himself and a mockery of the law, while at the same time forestalling the will of the American people. This is an elected president, the only national elected officer of our state, and they.
And Lou,
And I'm sorry, go ahead.
And Lou, that's, I think, why it's so important that we, you know, make sure that President Trump, you know, follows through on his campaign promise to fill a lot of the empty seats on the federal district courts and the federal courts of appeal, and especially the Supreme Court, because the best way to sort of maybe counter these types of orders is to put judges in place who really are going to sort of neutrally and in a blind way, even-handedly, apply the law as it's written.
And Josh, I love the analog that you created, the metaphor with Rachel Maddow. But unfortunately, I think it has the weight of truth in it. It's really an absurdist moment in law, is it not?
What we have here is that the federal courts are treating Donald Trump differently than they would treat any other president. He was elected. He was elected through the same Constitution by which these judges receive their lifetime commissions. And even if President Trump is breaking political norms, which he does every day, the court should not violate judicial norms. He should be treated like any other president, and the remedy is politics. But you get the strong sense in the opinions from these judges that Trump isn't your average president, and he's not subject to the usual scrutiny that presidents receive.
Well, it's clear, too, that these judges bear considerable scrutiny, certainly well beyond anything that they've experienced to this point. What do we do now, though? I mean, we have a president who is stymied by an out-of-control, I think we agree, an out-of-control district court pairing of judges, and we know that the Ninth Circuit Court of Appeals did not uphold the president in the appeal of the original order. So at this point, can the president not look to 212F of the U.S. Code and say, I have got the authority, look to the Constitution and say, I have the authority, and simply direct the Department of Homeland Security and to begin implementing what otherwise would have been encapsulated in the executive order? Is that possible, Barbara?
I certainly think it's something that the president could try and do, and I think someone who takes a very sort of robust view of executive power would encourage that kind of reaction. And unfortunately, that sets up a real constitutional crisis in our system, and it's something that, you know, I think in most eras and at most times the federal courts are very aware of, and they try and be deliberative and they try and be, you know, intentional about their decision making. And when they're not, as we've seen in the last couple of months in response to President Trump, it sets up precisely this type of problem. And at the end of the day, you know, I think the executive has a lot more power than the federal courts. So, you know, I'm not sure that it's the best approach for them.
No, it may not be the best approach, but these district court judges, who are obviously left-wing activist judges, have gone rogue and are telling the American people to go to hell and telling the President of the United States, whom they elected to go to hell, despite the fact that he has the authority of the Constitution, 212F of the U.S. Code, clear authority to do precisely what they are preventing from occurring. Josh, you get the last word.
Judges don't exist in vacuums. They, as Alexander Hamilton said, have neither the power of the sword nor the power of the purse. The validity of their judgments depend on their legitimacy. And when courts betray the legitimacy with these sorts of decisions, they become less reliable as an institution. So there's a distinct cost when judges go out on a limb like this and treat Trump differently than they would treat any other president because of who Donald Trump is.
Josh Blackman, Barbara Smith, thank you both for being here. We appreciate it.
Thank you.
Very much.